A very good afternoon, everyone. Firstly, myself, Lavika Gupta, advocate. I'm in the practice for the last 8 years, and I'm in the panel of United India Insurance Company, non-banking financial institution, BMC NGO, and Delhi Legal Service Authority, Central District. Firstly, I want to thank NIMT Educational Institution to give me the opportunity to discuss about the Arbitration and Conciliation Act 1996 with the students of NIMT. When we talk about Arbitration and Conciliation Act 1996, firstly, I'm talk about the arbitrator. Who are the arbitrator? The beauty of the act is that arbitrator can be of the any person, be it a lawyer or a judge or an expert, like in Indian Evidence Act from section 45. The expert can be of any person who are capable of doing the work. Then when we talk about Arbitration and Conciliation Act, the beauty, it's a very small but important and deep act, which is a very powerful impact on the Indian society, mainly in the civil cases, commercial disputes, trade disputes between the parties, and tax. It's not apply in the tax matters. Then when we talk about the courts, the first thing which came into the mind of every student is that courts are very overburdened, and they are very pendency of cases, a lengthy process, expensive process, and very much overburden of the judges. To reduce the burden of the courts, our legislature has evolved various processes like Lok Adalat, mediation, and Arbitration and Conciliation Act is one of the innovation, I can say, of our legislature to overburden the overburden our courts. And the beauty of the act is that the arbitrator can be of any person, and it's very small act with almost I can say that only 86 sections, but it's very deep and very important. And when let's talk about Arbitration Act, and when when we talk about arbitrator, as I told earlier, can be of any person from any field. And the when let's take an example. We talk about the Arbitration Act with an example. If two parties doing the trade with them, suppose I have and as I have told earlier that I'm in the panel of non-banking financial institution, or on behalf of NBFC, I have dealt with many arbitration cases in which they have made arbitration agreement with the parties. And as per the clause of the Arbitration Act and Conciliation Act, Section 7 of the Act says that arbitration agreement can be inserted in the agreement itself as a clause, or it can be entered between the parties separately, according to which parties are settled their terms with themselves, that if any dispute arose between the parties, then the matter have to be referred to the arbitrator, which can be of any person, and that will be appointed by the consent of the parties. Let's talk about the Arbitration Act with the practical example. Suppose A had sold the goods to B, uh, and A reside in Delhi and B reside in Bombay, and the transaction took place in Lucknow. Then they had agreed that if any dispute is arose between themselves, then all the proceedings are deal with in Delhi only, because the seller who sold the goods is reside and workplace in Delhi, and they have entered into an arbitration agreement that if any dispute arose, then that have to be solved by the arbitration clause. and A sold the goods to B and then entered into an agreement. But goods were supplied by A to B, but B had not given the amount. Then A had filed a suit to recover the amount before the Honorable Delhi courts. So when the notice was served from the courts to the B for the recovery of the A amount, then B have the right and take an objection. Then as per the agreement entered into between A and B, there is an arbitration clause, an arbitration agreement, according to which if any dispute arose between the parties, then have to be settled or sought out by the arbitrator, which is appointed by the parties themselves. Then courts are bound by the arbitration agreement and have to send the dispute to the arbitrator, which was appointed by the parties. And as per the section of the Arbitration and Conciliation Act, arbitrator have to be in the odd number only. It cannot be in the even number like 2, 4, 6. They have to be in the odd persons like 1, 3, or 5. And a sole arbitrator can also be appointed by the parties. And if the parties agreed that the sole arbitrator is appointed only by one of the parties, then also before appointment of the arbitrator or before invoking the arbitrator proceedings, the person who are bound to start the proceeding have to send a legal notice, have to send a notice to the other parties to start the arbitration proceedings. In short, if A has, as per the agreement entered between A and B, if the appointment of the arbitrator is in the hand of A only, but still A have to send a notice to be that I'm going to start arbitration proceeding against you, and you're bound by the agreement which is entered between us, and I'm appointing that arbitrator to solve our dispute. And on that point, B has a right to object on the appointment of arbitrator on the ground that the arbitrator which is named by A is not an impartial person, because it can be of any ground or any objection which can be hold, because B can say that the arbitrator which is named by A in the proceeding is the employee of A or is impartial towards A. Then in that case, B has a right to raise an objection and can go to the civil court for the appointment of arbitral tribunal from the court of law. And in that case, court of law enter into the picture again, and the appoint if court believes that the appointment of arbitrator is not in the impartial way by A, then court has a right to appoint another arbitrator or tell the parties to appoint another arbitrator. It's a point when only sole arbitrator is appointed by only one parties. When arbitration agreement says that the arbitrator tribunal needs to be made, needs to be started if any dispute arose, which includes 3 or 5 arbitrators, then both the parties have a right to appoint one arbitrator each, as per the section 11 of the Arbitration and Conciliation Act. And the third arbitrator is appointed by both the parties mutual understanding or mutual consent. So by that practical example, I am telling about that if arbitration agreement or agreement entered between the parties says that all the dispute, if any dispute arose between the parties that have to be solved by the arbitration agreement, then that have to be taken before the arbitrator. But civil courts jurisdiction is not barred to entertain the dispute. Suppose if before starting the arbitration proceeding, any party or any party in the agreement wants an interim relief because he he in the impression, or the party is in the impression, that other party destroy the subject matter of the dispute, or they can flee away from the jurisdiction of the court. So they can file an application or petition before the court, which has the jurisdiction to deal with the matter under section 9 of Arbitration and Conciliation Act, before invoking the arbitration proceeding, to apply to the court of law for initiation, or to grant an interim measures to him or the party, due to which they can preserve the subject matter of the dispute. For example, like in non-banking financial institution, if a non-banking financial institution gives a loan to on to B, let's take an example. A is a non-banking financial institution who gives a loan to B for the purchase of Bajaj Auto. Then in that case, we have taken a loan of suppose 3 lakh rupees, which needs to be clear in 36 monthly installments. But in between of the proceeding, B had disputed, or B had not paid the installments, and the non-NBFC, non-banking financial institution, is in the impression that B can destroy the subject matter, and here the subject matter is that Bajaj Auto, regarding which NBFC has given the loan to B. So they can, before initiating the proceeding before the honorable arbitrator, NBFC can file a petition before Section 9 of Arbitration Act before the learned court of law for preservation, or take the possession of the auto, due to which they can preserve the subject matter, and thereafter they can start the arbitration proceeding. And in arbitration proceeding, they can file an application under section 17 of the Arbitration Act before the learned arbitrator to sold out the auto or subject matter. So by that example, or by that thing, I'm sharing with you that by by arbitration agreement not barred the jurisdiction of the honorable courts also. So here we have discussed about the arbitration agreement, which can be a clause in the agreement entered between the parties, or which can be a separate agreement in which parties can enter. And we have also discussed about the appointment of arbitrator, that arbitrator can be of any person, can be of any field, and he can be of any expert, but it have to be in odd numbers, like 1, 3, and 5. Let's discuss about the powers of the arbitrator. When we talk about the arbitrator, he is a judge who is appointed by the parties to resolve the dispute which is arose between them due to the agreement, and due to any of laxity which remain in the agreement, or non-performance of part of the agreement. Then arbitrator has full power which a civil court has. Like he have to take an evidence. First complaint is filed before the honorable arbitrator, then he give us issue a summon to the respondent in every mode which a civil court has a power, like dasti summon, and a fixation, publication. Arbitrator has all the power. Then respondent came, and evidence then respondent came, then issues frame between the parties, then complainant has filed their evidence, then respondent, and the arguments is heard between the parties. Then after the arguments is heard, then arbitrator is bound to pass the award. The award is known as a decree. So by this I'm going to say that, okay, arbitrator has all the power which a civil court has to resolve the dispute between the parties, be it an evidence, be take a cross examination or examination. But in 2021 amendment, recently legislature has stated, because arbitrator proceeding is a speedy proceeding, and it is started to make the dispute resolve in a short span of time. So they have limited the proceeding in 6 months time bound proceeding after the completion of pleading. Means if a pleading is completed between the parties, then within 6 months the proceeding have to be completed by the learned arbitrator. But by the consent of the parties, 1 month extension can also be given by the learned arbitrator to the honorable parties. Then that proceeding or that clause is added. 29A clause is added by the 2019 amendment by the legislature, because to make the proceeding of the arbitration speedy, and by this they can uh, they can easily or fastly resolve the disputes between the parties. Then if we can talk about the proceedings, once the proceedings is started between the parties, then it is slowly going on in the way as it's going on the civil court. So when the pleadings is completed, at the point of evidence, the parties have to present their evidence, all the documents which have lie between them, and made the arguments before the learned arbitrator. And when the argument is heard, then award is passed by the honorable arbitrator, which have to be returned, duly dated and signed by the honorable arbitrator, and have to be passed on the stamp paper, which is purchased on the name of the parties. And when an decree or arbitral award is passed, then that have to be a one original copy have to be sent to both the parties by the arbitrator. And and if that is ex parte award. Ex parte award means when the notice was sent or summon was sent to the respondent by the honorable arbitrator, if respondent not came forward despite the duly service of the summons, then arbitrator has a power to make the respondent ex parte, and after going through the evidences and all the document presented by the claimant before the honorable arbitrator, he can pass an arbitral award. And in that case also arbitrator is bound to serve the arbitral award to the respondent who is ex parte, even ex parte, because as per section 34 of the Arbitration and Conciliation Act, the respondent has a right to raise an objection before the honorable court of law. It's kind of appeal or raise an objection against the arbitral award before the honorable court of law. And when we talk about section 34 of Arbitration Act, then we have to go through various aspects of section 34, which deals with on various which deals with the grounds in which the objections can be raised by the any objection can be raised by the parties before the court of law. When we talk about the objections, objection can be raised on the ground that the appointment of arbitral tribunal was not as per the law. Because if in the starting, if person has not raised an objection, then if the award was passed and he came to know that arbitration proceeding was started against me, in which an award was passed, but then he can say that if that I have not informed by the claimant that arbitration proceeding was started against me, then he can say that the composition of arbitral tribunal or the composition or appointment of sole arbitrator is not as per law. Secondly, if the parties who was started the arbitration proceeding was not capable of invoking the arbitration proceeding, then it can be a ground of raise an objection. Incapacity here means the party who entered into the agreement was dead or was died. Then in that case, it can be a ground to raise an objection before the court of law. On that point, I am I will share one of my judgments with you all guys. In my case, which was decided by the Honorable District and Session Judge T. Hazariko Central District, in which a arbitral award of 6 lakh was passed against my party. In that matter, my party was just the legal heirs of the guarantor, who was died long back ago, when the arbitration proceeding was started. Then, in that cases, in the award itself, they have not deal with the aspect that how the legal heirs of the guarantor is liable to pay the amount to the claimant. And as per section 131 of Indian Contract Act, if the guarantor was died uh, in between in if the guarantor was died, then his legal heir was not bound to pay the amount to the person who gave the loan. So on that point of law, learned district and session judge has set aside the arbitral award against my party. So that can be one of the ground in which the party can request the court of law or can approach the court of law to set aside the arbitral award against themselves. Then another aspect in which the objections can be raised by the parties against the tribunal is that the party has not received any kind of notice either from the other party, which is the claimant, or from the arbitrator for invoking the arbitration proceeding. And the fourth point of the objections which can be raised by the party under section 34 of Arbitration and Conciliation Act is that the award which was passed by the honorable arbitrator is against the public policy of court of law or against the public policy of law of land of India. For example, what are the public policies? Like in India, we say that gambling is banned. But if two persons agree or agreement on the point that we will gamble, and if one person is succeeded, that other person have to pay the amount. But the person succeeded, but the other person B has not paid the amount to A. Then in that case, A has started the proceeding of arbitration because a written agreement was entered between the parties. So they have entered into an arbitration clause as well, that if any dispute is arose between the parties, then that have to be decided by the honorable arbitrator. Then A have referred the dispute to the arbitrator, and arbitrator has also passed an award against B. But in India, gambling is banned. So B has a right to approach the court of law to set the arbitral award set aside, to get the arbitral award set aside, and that objections have to be filed within 3 months of passing of the arbitration award against the parties. And the court of law can extend the time within 1 month after the 30 days, after the lapse of 3 months, if court agrees or believes that other party approaches the court has a reasonable ground for not coming forward to the court of law. That's a aspect we have touched in the Arbitration and Conciliation Act. And when we talk about the jurisdiction which is in the limelight in today's era in many of the cases, because uh, because in arbitration agreement, the first example I have said that A reside in Delhi, B reside in Bombay, and the goods were supplied in the Lucknow, and they have agreed that the proceeding will be conducted in the Delhi if any dispute arose between the parties. Then in that case, as per the civil procedure code, all the courts has a jurisdiction, like where A resides is A, where A resides, that is Delhi, where B resides, that is Bombay, and where the goods will be supplied, that is Lucknow. But in the arbitration agreement, which was entered between the parties, the place of arbitration or seat of the arbitration is fixed, that is Delhi. So, in that case, if a place of arbitration or seat of arbitration is decided or fixed between the parties in the agreement itself, then only that court has exclusive jurisdiction in case of arbitration agreement, which is deal by the Honorable Delhi High Court in Arca Sports Management Private Limited versus Buildcon Private Limited. That's a judgment of 6th Feb 2020. In that case, the parties had entered into an agreement in which the the for invoking the arbitration proceeding, the party has filed a petition before the Delhi High Court on the ground that the goods were supplied from Delhi to Bombay. But in the arbitration agreement, which was entered into between the parties, they have decided that if any dispute will be raised between the parties, or if any dispute arose between the parties, that only Bombay courts has the jurisdiction to deal with the matter, and no other court has a right or jurisdiction to deal with the cases. Then, in that case, Delhi High Court clearly and specifically stated that as per the agreement entered between the parties, only Bombay courts has a jurisdiction to deal with the matter, and Delhi court has no jurisdiction, because if the seat of arbitrator is fixed, then that court has exclusive jurisdiction to deal with the cases. Why I'm talking about the jurisdiction in arbitration proceeding? Because in civil cases, when we file a dispute for the recovery between for dispute of recovery to recover the amount, then we can then, as per the section 21 of civil procedure code, the courts where the cause of action has arise has a jurisdiction to deal with the matter, or from where the goods was supplied, or where the respondent is resides or carry on business for work and gain. The has court that court has jurisdiction to deal with the cases. And in arbitration proceedings also, the civil courts has supervisory jurisdiction, as I told you earlier also, that by entering into an arbitration agreement, the jurisdiction of courts is not exclusively or permanently barred, because parties can approach to the civil courts to get the interim measures or interim protection for the subject matters, or they can approach the courts in between of the arbitration proceedings as well, like in if the arbitrator is appointed. Because in when we that I can told you by a example, that in builder buyer agreement, the builder has entered into an agreement with the buyers, and in builder buyer agreement I have gone through that builders has write the clauses that if any dispute arose, then only builder has a right to appoint an arbitrator, and he has the exclusive jurisdiction or exclusive right for the appointment of arbitrator if any dispute arose between the parties. That in that case, if any dispute arose, then builder appointed his arbitrator, and sometimes they have not sent the notices to the other parties, and our award is passed, and only the award copy was received by the respondent. Then in that case, if the respondent has a respondent approach to the honorable court can to get the award set aside, or in between of the proceeding, if notice was sent to the arbitrator to the respondent, then respondent can raise an objection. If respondent can raise an objection before the honorable arbitrator, that at the time of invoking the arbitration proceeding, the claimant, who is a builder, has not sent a notice to me regarding the appointment of arbitrator, then in that case, if arbitrator has decided the issue against the respondent, then respondent can approach to the honorable court of law for set aside the arbitral tribunal and for the fresh appointment of learned arbitrator on the ground that the arbitrator appointed by the builder is not is partial and is not taking the case as per law of the land. One more thing, when we talk about the arbitration agreement or arbitration clauses, then before when arbitrator is appointed by the parties, then if arbitrator is in any way entrusted with any of the parties, then that have to be revealed by the arbitrator to both of the parties that I'm related to that party in that sense. And if other party object for the still object for the appointment of arbitrator, then uh, then another arbitrator can be appointed by the parties, or the matter can be sent to the court of law for the appointment of arbitrator. Then we have came to the fact that the cases which can be referred to the arbitration can be of civil dispute, construction dispute, insurance matters, non-banking financial matters, or recovery suits or time barred debts. That because in that cases the proceeding is conducted in that cases proceeding can be conducted before the arbitration or before the learned arbitrator, or the matter which cannot be sent to the arbitrator is text, will, which is will matters, and the matrimonial matters, guardianship matter, trust matters have if that matters is sought out or resolved by the honorable arbitrator or any arbitral tribunal, that it is barred by law and that it is not according to the law of the land. On that ground also objection can be raised uh, objection can be raised by the party against the arbitral award, and it can be set aside by the honorable court of law. Then if we talk about the award, then lastly if we talk about the award which can be passed, which was passed by the honorable arbitrator, it has four aspects. First, general. In award, in general thing, on the first part of the award, which is general, arbitrator have to be stated that claimant has sent the notice of invoking of the arbitral proceeding to the respondent, and as per the agreement entered between the parties, arbitrator was satisfied that the dispute can be referred to the arbitrator, and then summons was sent which is duly served to the other party. Then second aspect, which is the fact of the case. In fact of the case, honorable arbitrator has dealt with the issue which was came of filed by the claimant before the honorable arbitrator, in which the facts like I have set an example earlier also, that if loan was given to purchase an auto by a non-banking financial institution to be, then arbitration had deal with the facts on which a dispute is arose and why the dispute is arose between the parties, and if respondent came, what is the defense with the respondent, and if respondent not came despite the service of the summon, then the date on which the respondent was ex parte by the honorable arbitrator. Then third aspect of the award will be submissions. Submissions in the sense, what are the facts, what are the evidences was presented by the parties before the honorable arbitrator. Like uh, in loan matters, the part claimant has presented his AR, authorized representative, who can give his evidences and give all the exhibits of the arbitration agreement, loan agreement, or ID proofs or bank statements, which was duly maintained by the non-banking financial institutions with them. And then if the respondent came, then if any evidence which the respondent have with themselves, then that it have to be right by the honorable arbitrator in his or her award. Then then came the conclusion aspect. In conclusion aspect, arbitrator have to deal with all the things, all the submission, all the evidences which came forward before the arbitrator by the parties, on the basis of which, after dealing the law and after appreciating the facts or legal provisions, how the arbitrator came into the conclusion of the decision, like which amount can be given to the claimant, or claimant dispute was dismissed, or it was decreed by the arbitrator. When we talk about the dismissal or decree of the claimant claim, if the claim of the claimant is decreed by the arbitrator, then in that case, uh, arbitrator deals with the aspect of the law on the ground that how claimant is how claimant is liable or able to get an award in his favor, like in non-banking financial matters. Award when NBFC has given the loan to B for purchasing of auto. They have signed a loan agreement. They have maintained a bank of account in the name of B, and how many installments was given, how many installments were unpaid, and all the proceedings was detailed, and all the evidences was presented by the claimant before the arbitrator, and on the basis of the on the basis of the evidences, on the basis of the documents which was showed by the claimant to the arbitrator, award was passed and the matter was decreed. Then, in another aspect, when the claim was rejected or when the claim was dismissed by the arbitrator, what can be the grounds? Then, if like I told you earlier, also on the part of gambling example, the example which I have gave earlier, on the ground of gambling, the parties has entered into an agreement. Then in that case, arbitrator can deal with the aspect of the contract act, that gambling is banned between the parties. That on that ground, arbitrator can cancel or reject or dismiss the claim of the claimant and not pass the award. Then in that case also, either of the party can file an objection before the honorable court of law. Then if when we talk about the arbitral award, then if any error occur, or if any proceeding of any amount was mistaken, or anything which was written, there is a clerical error in the award, then parties can approach to the arbitrator within 30 days of passing of the arbitration award, and can say that, or can request to the honorable high court arbitrator to clear the lacuna or to clear the clerical error. And lastly, when the award was passed, if the parties are not satisfied, then they can approach the honorable court of law to get the award set aside. At conclusion, I'm saying, uh, I'm concluding on the fact that Arbitration Conciliation Act is a very short but very impressive, very important, and a very deep act, by which the beauty of that act is that in that arbitrator can be of any person from any field, like in buyer builder agreement. If a dispute arose between the parties regarding the making of the building, and if making of the building, that in that case parties can appoint a civil engineer in as an arbitrator in that dispute. Or if in like a dispute arose in GST matters, then the person who is expert can be of arbitrator. Because in court of law we find that we can we find that there are many pendency of cases, and to reduce the cases, Arbitration and Conciliation Act 1996 was made by the honorable legislature, and to reduce the overburden of the court, and to make the dispute settle between the parties fastly and through fast track courts, and all the powers of the civil court was given to the learned arbitrator by the honorable legislature. And the decree, or the award which was passed by the learned arbitrator, has the same power which a power of as a decree which was passed by the court of law. So, and the appeal was can also be filed against the arbitral award, and that can be set aside by the court of law. And to filing the appeal, the party have to approach to the court of law and can file a petition to get the arbitral award set aside under Section 34 of Arbitration and Conciliation Act. So, if anyone wants to raise a question, they can write it. Okay, so at the end, I'm concluded that if Arbitration and Conciliation Act is very much and very powerful act in the field of commercial matters, commercial dispute, civil cases, trade disputes, if any entered between the parties, and to invoke the arbitration proceeding, that can separate clause can be entered between the parties, or or separate agreement can be entered between the parties, or a clause can be entered right clause can be right by the parties in the agreement entered between themselves. So thank you everyone, and thank you NIMT for giving me the opportunity to discuss about the Arbitration and Conciliation Act. Thank you so much.